The record in the matter of the people of the state of Michigan versus Brandon Scott Craybill, file number 23-03160, council appearance. All right, can I have your appearance?
Good morning, Judge. Carrie Angie appearing on behalf of the Attorney General's office.
Thank you. And Mr. Brandon Craybill was present via Zoom. Today is the date that we reset this matter to give more time for the bond to be applied to his arrearage. Has that been taken care of?
Judge, it doesn't appear that it has. My records indicate that as of 2 days ago, the outstanding arrearage is $4,130.89. The last payments don't appear to match the bond amount, which may I trouble you by asking what the bond amount was so that I can confirm that.
Bond amount was supposed to be $3,431.
I am not showing any payment in that amount in the account. I do show that on November 3rd, 2023, there was the application of a $4,500 payment and also a $4,000 payment. Since I am covering the case today, I am uncertain as to when the bond amount was supposed to be applied, and I don't know if it falls into either of those November 3rd payments.
It does not. It was supposed to be, I've reset this 3 times so that the bond could be applied, and the last AAG appeared, I instructed him to follow up on it. Because Mr. Craybill continues to come to court for this, and the bond was posted and should have been applied a long time ago.
I have no explanation for that, Judge. I can't apologize enough. My payment history that exists through the friend of court is not indicating the application of that bond of payment as of today's date.
Judge.
Yes.
I looked as recently as this morning, and it has not showed the bond payment or the most recent child support payment that's been made. That would be the differential between the bond amount and the amount that's showing on the front of the court. So there hasn't been that application of the bond amount. So that's as much as I know.
Okay, I'm resetting this one final time. My expectation is the Attorney General's office is going to get on the phone or make a visit to the friend of the court and get to the bottom of this. I can't deal with every time someone appears, it's a different person who doesn't know what's going on. If they're going to hold this case open and hold this over Mr. Craybill's head, the expectation is that they're going to do what they need to do to make sure the bond's applied. He's posted it. He's even been current in making those payments that were accruing in between these court dates, because I reset this November 9th, I reset it November 17th, I reset it December 1st, and then I reset it again December 28th.
Yes, Your Honor, and I will be sure to get on top of that personally. I do want to advise the court and Mr. Craybill that my records are showing a payment of $680 made on December 27th of 2023. Also, just so that the record is clear, it appears it is charging at $680 a month, and there is only one child that is still an open case with friend of court. That said, I will personally find out where that money is and why it's not applied yet.
February 1st at 8:30. The new date.
Thank you, Your Honor. Definitely have an answer for the court and Mr. Crable on that date. Thank you so much.
Thank you. Do you have any questions, Mr. Craybill?
No, you said February 1st, correct?
That's correct.
Okay, thank you. That's it for me. Thank you.
Thank you. You're all set.
Thank you, Your Honor.
Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Shawan Calvin, file number 23-03121. Council appearance.
Prosecutor Paige Petrosky on behalf of the people. Karen Robinson, Assistant Public Defender for Mr. Calvin.
Mr. Calvin is present via Zoom. Can you hear me?
Yes, I can hear you.
Okay, thank you. Today was the date and the time that was set for sentencing. I do have a pre-sentence report with a recommendation. It was prepared back on the 5th of January, 2024. Did you get a copy of that, Ms. Robinson?
I did.
Do we need to make updates,
Not at
corrections,
this
or
time.
deletions? Need to make allocution.
Yes, Your Honor, we'd ask the court to follow the recommendation outlined in the pre-sentence investigation report with the 12 months of probation of the domestic violence class. However, we would ask the court to take out the drug testing provisions, as it doesn't look as if he has any sort of substance abuse issues going on. The questionnaire doesn't report any alleged substance abuse or any concerns in that matter, and that would be an undue expense for Mr. Calvin at this time. Right now, he is not currently working. However, he is actively looking for employment. He is willing to complete a term of probation, and so we'd ask the court to follow the recommendation.
Or did your client want to make a statement today?
No, he does not.
I reviewed the pre-sentence report and the recommendation, as well as review your prior criminal history, both from the state of Michigan and the state of Georgia. The recommendation is for you to complete or participate in a term of probation, that being 12 months, indicated that you have high needs in the personality domain, and then moderately high in family relationships domains. Obviously, moderately low needs in employment, leisure activities, attitudes, and responsivity. I do have a concern, though, that you're not employed. Although the report indicates a relatively low need, moderate low need in those areas. I would disagree with that. You probably need to do more things in the areas of employment and leisure activities in order to probably stay out of trouble. With that being said, I think the recommendation is overall appropriate. I will adopt it. You will be sentenced to a term of 12 months probation. While on probation, you will be required to obtain employment and provide verification of that to probation, okay? I'm gonna continue the no contact order with the Kenesha Embry. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance unless you have a valid prescription, and you will be required to submit to random preliminary breath testing and urinalysis testing while on probation, okay?
Yes, Your Honor.
Do you have any questions about your probation requirements at this time?
No. What'd you say, Your Honor?
Do you have any questions at this time regarding your probation conditions?
No, Your Honor.
There is a $75 crime victim rights fee that will be assessed. $50 will be assessed for count one and for count two for state minimum costs. There's a $30 per month oversight fee that you will be responsible for while on probation. So that's a total of $360 for probation oversight. I'm gonna waive discretionary fines and costs. The total fines and costs for count one and two will be a total of $535, and you'll make monthly payments on that, okay?
Yes, Your Honor.
There's an advice of rights as to probation. It says you have been sentenced to a term of probation in the 54A District Court. Your probation conditions are individually tailored and are specific to address your assessed risks and needs, except for domestic violence, criminal sex crimes, stalking offenses, or offense where the defense of guilty but mentally ill is asserted. You may be eligible for early discharge from probation. You are on probation for domestic violence, so you would not be eligible for a request for early discharge from probation, okay?
Yes, Your Honor.
Any questions at this time?
No, Your Honor.
Can you confirm your telephone number for me?
517-730-7517.
Okay, your address has not changed since you were arraigned?
No, Your Honor.
Okay. You'll be in contact with probation. They'll go over this order as for sentence, your sentencing order, and then you'll have to review and sign it, okay?
Okay, Your Honor.
Any additional matters for the record, counsel?
I think other people, Your Honor. No, Your Honor, thank you.
Thank you. You're all set, sir. On the record, in the matter of the people of the state of Michigan versus Sean Cassidy, file number 23-01066, counsel appearance.
Assistant Prosecutor Jane Petrosky on behalf of the people.
And Attorney Luke Goodrich, Public Defender's Office, here to represent Mr. Cassidy.
That might be him. I'm starting audio or starting video. Is that him?
Yes, that's.
You're referring to probation. Ms. Petrowski.
There we go. Hello?
Okay, we can hear you now. You're Mr. Sean Cassidy.
Yes. Mhm.
Okay, Mr. Cassidy, today's the date set for sentencing. You were here December 29th. You pled guilty to count 2, stolen property, receiving and concealing less than 200. I reset this, I believe, because there was a victim. Do we have a victim or any restitution?
I attempted to make contact with the victim in this case, but I wasn't able to do so.
Okay, you can make allocution.
Thank you, Your Honor. Your Honor, Mr. Cassidy's had some significant mental health issues that ended up delaying this case in the spring. He has been working on addressing some of those issues. In September, his wife was diagnosed with a very serious heart condition, and he's been primarily spending most of his time recently assisting her with her condition. By my count, I have that he did 2 days in jail when he first got arrested, and then was in jail for 23 days in December after he got arrested on the bench warrant in this matter. So I would ask the court at this time to sentence him to a time served of 25 days in jail, Your Honor.
Okay, Mr. Cassidy, did you want to make a statement at all?
No, ma'am.
Okay, the sentence is 25 days Ingham County Jail, credit time served. You're all set, sir.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you. On the record, in the matter of the people of the state of Michigan versus Tyler Grinnell, file numbers 23-03666 and 23-01958. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Mr. Grinnell, can you come in the courtroom? And Assistant Public Defender Sarah Donnelly on behalf of the defendant Tyler Grinnell, who will be standing in front of me and to my right now.
Today was the date set for a pretrial on a retail fraud and a plea on receiving, concealing a stolen vehicle. How are we proceeding?
It's my understanding the defendant would be accepting a plea offer as a part of a global resolution in this case.
Their plea sheet?
Your Honor, we're still working on the plea sheet and the plea agreement at this time. We might, I would just recommend that we go off the record. But yes, that's our extender. We're trying to do a plea.
Okay, on the record in the matter of the people of the state of Michigan versus Maurice Myers, file number 23-02984. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Maurice Myers, who is present and standing to my right.
Okay, Mr. Myers, today was the date that we reset your matter because you were being screened for the 30th Circuit Court. How are we proceeding today?
Your Honor, yes, he's did his CMH assessment yesterday, so that his screening in the Circuit Court's mental health court is going along. We would ask for a 30-day adjournment.
February 15th at 9. Do you have any questions today, Mr. Myers? Get your notice to appear any additional matters for the record on this file.
Nothing from the people, Your Honor.
And nothing for defense.
Okay, you're all set for today, sir. Is Ms. Wanji outside?
She might be here.
Are we running? Russell, I need to know if we're running.
Your Honor, which matter is she?
William Russell.
Okay, because it has the other. Yeah, and it had it like on the writing version. Yeah, so it's like she has that. Um, yeah.
Yeah.
We're not trying to make it work, because that's how.
Yeah.
we do it. So,
And then remember I said. Yeah.
And then,
Resetting part.
You won't get file stacked.
Oh, yeah, it was Mr. Darren.
Looks like LPD couldn't pick them up.
Is that what happened? Because I was wondering if he was downstairs. I went downstairs earlier.
I forwarded you the emails that.
Okay.
Day stand.
They wanted LPD to come out to Calhoun County and get him? That's insane.
Personal day stand. And then it just goes back
Yeah.
out.
Okay, all right, I understand. Do you know if they do video writs? Because he's just gonna leave.
I don't know. I don't think they do. I think they're one of the more difficult counties.
All right, so we'll just have to do that one. Okay, and
I think it was part of it. Anyway, so no,
February,
So.
yeah, so I want to make sure that you,
February 22nd at 10.
considering for Clark.
Yes.
so, because he has the other,
Yep.
open retail front case with me. So that one, that case would be.
Mr. Russell, you can have a seat because I don't know where your attorney is.
I'm here.
Oh, I can't see back there. Oh, okay.
Guilty to the.
All right, I'll call your case. On the record in the matter of the people of the state of Michigan versus William Russell, file number 23-03364, council appearance.
This is prosecutor Paige Petrowski on behalf of the people.
Okay, Mr. Russell, today was the date and time set for preliminary examination. Are we running the exam today?
It's my understanding that we are not running the exam today and that defendant will be accepting the plea offer.
Oh, no, if it's, he's a red space.
Okay, I have a plea sheet, states the people are offering for you to plead guilty to added count 4 of attempting, resisting, obstructing, and added count 5 of attempting, resisting, obstructing, and they'll dismiss the remaining counts. That's what you understand your offer to be. You want to accept it? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay. I have an advice and rights and plea information sheet. This is your signature.
Yes.
Did you read this document?
Yes.
You understand the rights listed here?
Yes.
You have any questions about these rights? And you're willing to give up all of those rights today in order to accept the offer and plead guilty to 2 counts of attempted resisting, obstructing an officer?
Yes.
And so that means that you're gonna give up your right to the presumption of innocence, so you're innocent until proven guilty. You understand that?
Yes.
You have the right to require the prosecutor prove your guilt at trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have sounds be used against you. You have the right to confront in court and cross-examine any of your accusers. You have the right to call your own witnesses to testify at trial or present evidence that you believe further a defense of the charge or charges being brought against you. You're willing to give all that up?
Yes.
Has anybody made any threats to you to get you to give up your rights and plead guilty?
No.
Any promises being made to you in exchange for a guilty plea? Are you currently on probation or on parole?
No.
You understand that a guilty plea could have an effect or impact on travel or immigration status you may be seeking. So you may not be able to travel certain places if you get a conviction of this kind.
Yes.
You also understand that a guilty plea could result in the conviction that you may need to report to your employer.
Yes.
Okay. As to the added count 4 and added count 5 of attempting or attempted resisted obstruction of an officer, how do you plead?
Guilty.
Can I have a factual basis, please?
Yes, Your Honor, thank you. Mr. Russell, on November 7th, 2023, were you in the city of Lansing?
Yes. Oh, sorry. Yes.
And it's to the best of your knowledge, it's in Freedom County, correct?
Yes.
And you were traveling, you were a passenger in a car, is that correct?
Yes.
And that car was stopped by the police.
Yes.
And when the police stopped the car, they approached the passenger seat, is that correct?
Yes.
And you were in the passenger seat and you were given an order that you did not obey.
Yes.
And you knew that they were police officers because they were wearing their police uniform. And you know that the order that the police officer was giving you was very clear. You had warrant and they want to arrest you. And when they asked you to get out, you did not obey.
Any questions from the prosecution?
No, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea. If your plea you made freely, voluntarily, and intelligently.
So I did not count for 5.
I'm sorry?
He has to count. Will that satisfy both counts because it's the same?
It's the same. I assume they were the same transaction.
I believe in the getting the facts,
this one, he was using officers, both officers were giving commands.
That's what I see in the police report, so.
I just want to.
Yep, it was 2 officers, one incident, so that satisfies the factual basis for this purpose. And then he was arrested, how long was he in custody? You have other matters pending, I know. He was-
Dog licenses.
Dog license,
That's all I have left.
okay. Look at that, you can proceed to allocution,
3 years later.
you can make allocution.
Thank you. You know, as you know, Mr. Russell is very pleasant gentleman. And we have discussed this matter and we reviewed the discovery. And at the end, he believes that this is the best way to conclude this matter. He did receive a bill, but I think that he understands that had he obeyed the order, this would have not happened. He would have been going to jail. He's very remorseful about what happened. And to tell the truth, when I reviewed the video, he actually apologized to the police officers. He really apologized to them. And at the end, the encounter finished. There was no more problems. And he was taken to the jail without any further problems, Your Honor. And so I do believe that Mr. Russell is ready to get out of your courtroom forever. He told me that he's been dealing with you for many years. And,
Indeed, we've come a long way, Mr. Russell. From red tag property trespassing to.
I'll just over renovate.
Yeah, we just want you to do what you need to do in proportion with the law. That's all we want. We want you to have your pets. We just want them to have dog licenses. We want you to renovate your house. We just don't want you to be in there when you're not supposed to be there if it's red tagged. You know, we want you to comply with the officers if they give you an order. That's all we want you to do. I've never had anything that I can recall of a interaction between us that was unpleasant, but I do see that you have some things that could make you tick, I see, and it brings you before the court. And I'm hoping that 2024 is going to be a better year for you. And we don't, because I think the public defender's office also would like to break up with you as well.
Right.
I think it's time.
Right,
You know,
I'm sure you're tired of looking at.
Yeah, I mean, I really enjoyed your holiday blazers, but I think it's time for us to do something different in 2024, okay? With that being said, I'm gonna credit you time served. And you're all set.
Thank you.
Thank you.
thank you.
What are we doing with Solace?
Oh, he did his too.
I believe that is a vertical case being handled by one of our office's customers. That one, I believe, is Mr. Pfeiffer.
Okay.
You're up 3 minutes.
Okay, Mr. Grinnell, you can come back on the record in the matter of the people of the state of Michigan versus Tyler Grinnell. And have a plea sheet, Mr. Grinnell. The people are offering for you to plead guilty to an added count 2 of stolen property, receiving, concealing $200 to $1,000, and that the people will in exchange dismiss open cases with retail fraud charges. How many of those are there?
There are currently, sorry. We have
one active case, and then I believe we have at least 3, and I'm double checking if it's not 4, cases that have been reviewed and just haven't been sworn to yet. So we would be dismissing those that haven't been sworn to yet.
Okay, so this just is open cases and not pending cases. So that's why I asked what was open.
Oh, one is open 23-01958 dash.
That's what we're here for today. And she's saying that there's gonna be additional that's dismissed as well.
The ones that they have already reviewed and they haven't issued yet, they are not going to. Is what they're, so they're,
Okay,
you're not
that-
Yeah, we're
you're not
just-
gonna issue.
This
Yeah.
needs to state that.
I'm
Oh,
sorry,
No problem. Just so it doesn't get missed
Yeah.
and issued, and then I'll transfer that to our file. And that's what you understand your offer to be, that you're going to plead guilty to the added count of retail fraud. I'm sorry, receiving and concealing 200 to 1,000, and that the retail fraud in file number 23-0958 will be dismissed, and then the ones that are pending will also not be issued. Okay, you understanding? Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. Okay, and I have an advice of rights and key information sheet with today's date on it. Is this your signature?
Yes, Your Honor.
Did you read this document?
I did.
Do you understand each of the rights that's listed here?
Yes, Your Honor.
And is it your intention to give up these rights?
Yes.
Okay, so that means you're gonna give up your right to the presumption of innocence. So you're innocent until proven guilty, and you have the right to require the prosecutor prove your guilt at a trial, and you have the right to jury trial, and you have the right to require them to prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent and not have silence be used against you at your trial. You have the right to see, hear, question, and confront any of the accusers or the witnesses that the prosecutor calls against you. You have the right to have witnesses subpoenaed on your behalf to testify for you, and also to present evidence that you think show a defense to these charges. You understand that? And you want to give all of that up. Anybody threatening you to get you to do that?
No.
Has anybody made any promises to you in exchange for you entering a guilty plea today? Are you currently on probation or on parole?
Yes.
Okay, which one?
Probation.
Where?
And 55.
He was recently put on it by Judge Hillman and it's the PD case he's on bond for.
Okay, so then these are not likely to have an impact on your probation status. You understand that?
Yes.
Okay, but if you were on probation previous to that, a guilty plea could impact your probation status. You understand that?
Yes, Your Honor.
Also, you understand that a guilty plea may be something that you may need to report to your employer or to a future employer.
Yes, Your Honor.
Lastly, a guilty plea could have impact on travel or immigration status you may be seeking. So you may not be able to travel wherever you want with these kinds of convictions. You understand that?
Yes, I do.
As to receiving and concealing stolen property, 200 to 1,000, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty? That's your basis.
Thank you, Your Honor. All right, Mr. Grinnell, on December 9th of 2023, were you driving a Dodge Ram in at or near Mount Hope and Aurelius in the city of Lansing, Union County, state of Michigan?
Yes, sir.
And while you were operating and possessing that Dodge Ram, did you know or have reason to know that the vehicle was stolen? Or did you have a reason to believe that it was stolen? Yes, okay, all right. And you had contact with the Lansing Police Department, correct?
Correct.
All right, and you had also told them that you had suspected at some point that it had been stolen, right?
Correct.
Okay, Your Honor, I have no further questions.
What does possibly mean? What does that mean? You possibly knew? This question is for you, not your attorney.
Yes, Your Honor. I ran the VINs to make sure that it was not a stolen vehicle, and so it's my assumption that it wasn't at the time, but there's always a chance that anything could be when I do different work for Craigslist, things like that, so, I mean, the plate was expired, so I checked that.
The plate was expired and you checked the VINs? And did the VIN say, the VIN tell you it was stolen?
No,
Okay, so what made you believe that it might be stolen?
just didn't know the people. I mean, I typically check. I've been an insurance agent. I've been
Did you buy, or did you buy this vehicle
No,
or were
I was
you,
using it for work.
you borrowed it?
They let me use it to do jobs, yes,
Someone lets you use the vehicle to do jobs?
correct.
And do these people have a history of stealing cars?
I don't know. No.
Oh, you don't know that much about them? You just were using a car and because you were using someone's car, there's a chance that it may be stolen?
They acted a little different. I mean, they could always pay me on time. I've driven that two other prior occasions. Where I made sure I checked everything. I always do that. I mean, you just never know.
That's a good practice if you're gonna use other people's cars to check it.
Yeah.
What's more than what most of us do when we wanna borrow a car? I don't check people's VINs. I guess there's a chance that if I borrow someone's car, it could be stolen. I don't know that I have a factual basis though.
I've been a car wholesaler, a car dealer. It's just a habit.
I get it, but based on what you're telling me, I don't see why I would accept a plea for receiving concealing when you did your due diligence to see if the car was stolen.
The problem is that he said that is after he checked the VINs.
Is there anything else? Because I don't see where he received and concealed stolen property or had an intent to do that. It looks like he checked the VINs. He was borrowing a car.
Mr. Grinnell, you said that the truck you were driving had expired plate, right?
Correct.
Was it your plate
No.
or was it,
So
so,
I changed the plate to my in-transit plate that I have for work, for on-site vehicle services.
so when you received the truck, it didn't have a valid plate on it?
Correct.
Okay, and you used your own plate to put it on?
That is correct.
Does that make you suspect that the truck was stolen?
Yes. I mean, yes.
The fact that it didn't have a valid plate makes you think it was stolen.
There were just incidences that, the way they talked, I don't know. I'm not sure.
The people gave you some concern?
Yes.
Okay, okay. Now we're getting to what's going on. So you had a conversation with these people and what they shared with you caused you to have concern that this car was really theirs.
Yes.
Okay, sounds good. Any additional factual basis?
No, Your Honor, thank you.
The court is satisfied with the factual basis. I'll accept your plea, finding your plea to be made freely, voluntarily, and intelligently. How many days was he in custody?
Was it just the night that you got arrested or?
It was, on the weekend, so 2 days, Saturday, Sunday. Monday.
Was there any restitution in this at all?
Not in this case, Your Honor.
You can make allocution.
Thank you, Your Honor. As already stated, Mr. Grinnell is on probation. Judge Hillman put him on 12 months probation. When did he leave it?
Started last Monday.
Last Monday with a tether. So Your Honor, with that, we'd be asking, and of course, Mr. Grinnell, he works, struggles to work, especially finding, legitimate employers. So he would have very little money for fines and costs. So we just ask that any discretionary fine be waived.
He struggles with, construction, freelance construction.
Yes.
He works for himself then, doesn't he? No?
I work for myself and others. I mean, whenever there's work, I'll work 80 hours a week if I could.
And he'll be able to continue to work, Your Honor, because he won't be losing his license for this.
So when I have to pay for 2 drug testings a week, and I meet with mental health, lady today for assessment.
It's part of your probationary term, is that what you're saying?
Yes, ma'am.
Okay, I'll credit you time, sir, if you're all set. The other files dismissed.
Okay, for Denali.
Yes, who's the knowledge, or this one?
Yeah, for the.
I need to move that again.
All right, thank you.
Mr. Grinnell, let us get you a copy of this Nolly.
Starting there, it's not.
Lanier's the only one. Are you on Lanier? Which one are you on?
Dallas.
Oh, Salas. Lanier, The attorney's not here. I don't even know if he's here.
Oh,
Lanier
Mr. Freeman's in the
is here.
hallway. Already.
No, I said Lanier.
Sorry.
Ms. Wanji, what are we doing with Summers?
I can send it. It doesn't take me that long. It's fine. Okay.
We're gonna request another adjournment. There was no, the lineup has not been done yet.
Oh, is Summers here?
About,
Got Summers? Okay, on
Oh,
the
I thought it
record,
was gonna be Freeman.
on the record, in the matter of the people of the state of, there's a lot of like background noise, a small courtroom. On the record, in the matter of the people of the state of Michigan versus Jaron Michael Summers, file number 23-02864, council appearance.
Mr. Prosecutor Petrowski on behalf of the people.
Assistant Defender from the Defender Office. Or Mr.
Summers.
Thomas.
Okay, Mr. Summers, how are you?
All right, myself.
I'm doing well, thank you. Okay, so today was the date and time that was set for a preliminary examination. I do have a note here back on December 7th that there was a request for a lineup. That lineup has not been done yet.
That's correct, Your Honor.
Do we know when it's gonna be done?
So I received an email from Ms. Wanji, and I apologize, I'm taking on this case kind of halfway through the process. I found out on what? This week that a lineup had been ordered and had not been completed. I made Ms. Wanji aware as soon as I realized it hadn't, and I have got the everything in motion with my office to get that schedule done as soon as possible. I apologize for the delay.
What are we looking for timelines for that?
I'll be perfectly honest, I don't exactly know. I know that there's a couple different moving pieces. Given that it has to be double, if it's a corporeal lineup, it has to be done double blind, so we have to have both just a prosecutor available to go and do it. And then I believe also make sure that we have officers and everyone. But
30 days.
30 days.
Yes. March 8th. March 8th at 8:30. Do you have any questions for the court today, Mr. Summers?
No, Your Honor.
Okay, any additional matters for the record today?
So, yeah.
Okay, we'll get you your notice to appear, okay? So now we have Solace.
You
said what?
It's gonna be a felony plea.
Yeah, understand.
Yeah.
On the record, in the matter of the people of the state of Michigan versus Bradley Salas, file number 23-02750. Council appearance.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of.
Good morning, Your Honor. Stephen A. Freeman on behalf of defendant Mr. Salas, Public Defender's Office.
Okay, today was the date that was set for preliminary examination in the TA 53 contempt hearing. How are we proceeding?
Your Honor, the people are, well, both sides are seeking to waive the examination today and not go forward in the PA 53. There has been a plea agreement that has been reached in this matter, and as a result, we would ask it to get up to the circuit court as soon as possible, which is also why when it's bound over, both sides are requesting that the circuit court arraignment do actually occur, as that will help us get a plea hearing far more quickly.
Okay, we get to file a motion for a social court arraignment, is that correct?
Granted, I have not had to request one since they've made the change, but.
You have the motion for arraignment.
Okay, we can, do we have to file the motion with the district court or the circuit court?
I would imagine it's with the circuit court, because
Okay.
we're not the ones.
If you didn't know, then it's definitely the circuit court.
Yeah, I'm pretty sure that they're the ones that require that, so.
Perfect.
I would note that on the file.
Thank you. I'll make sure to reach out to the circuit court after today's hearing.
And I will place this advice of rights in the file.
Yes, Your Honor.
Okay, and so, Mr. Salas, you understand that you have the right to have a preliminary examination here in the district court?
Yes, Your Honor.
You understand the purpose of the preliminary examination?
Yes, Your Honor.
So you have the right to require the prosecutor to put forth evidence to establish that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. You want to freely and voluntarily give up that right today?
Yes, Your Honor.
Anybody threatening you to get you to do that?
No, Your Honor.
Has there been any promises made to you in exchange for you waiving?
Your Honor, at that point, I would like to put the plea offer on the record because that has been the promise that's been made to Mr. Salas.
Okay.
The offer in this case is for the defendant to plead guilty to count 3, felony firearm third offense notice, count 5, firearm possession by a felon, and count 8, domestic violence second offense. In exchange, the people are agreeing to dismiss the other counts, not to pursue a count of possession of a short barrel shotgun / rifle, and agree not to pursue witness interference charges for contacts made with the victim, we will say prior to today's date, that being 1/11/2024.
Mr. Freeman, that's accurate.
It is, Your Honor. Thank you.
Okay, and so, and other than what was stated on the record, has there been any promises to get you to want to waive your examination?
No, Your Honor.
Okay. You understand that the waiver is unconditional and you're not gonna be able to change your mind once this matter gets to the circuit court. You understand that?
Yes, Your Honor.
Find your waiver to be freely and voluntarily made. Your bind over date's gonna be January 24th. That's the date they'll get the file from this court. Your attorneys and the prosecuting attorney are making a joint motion for a new arraignment at the circuit court. They'll be advised of the date that you'll appear for that, okay?
Yes, Your Honor.
Do you have any questions at this time?
No, Your Honor.
Any additional matters for the record?
Nothing from the people, Your Honor.
If I may,
Yes.
thank you very much, Your Honor. Before the district court, let's go with this case as it were. I believe that this court previously ordered Mr. Salas to be denied certain privileges at the Ingham County Jail, telephone, personal visits and messages, I believe. In light of the fact that the parties have now reached an accord, and I was wondering whether the court might take a second look at that prohibition. My client's been in jail now for what, 4 or 5 months, I believe. And if the court might inquire of counsel or inquire of Mr. Salas and perhaps reinstate those privileges. Thank you.
Your Honor, given the nature of the charges that he is planning on pleading guilty to at the circuit court, we would leave this in the discretion of the court.
Okay. The phone privileges and email privileges were restricted due to the allegation that there were 14 phone calls within 14 days to the alleged victim, 5 times the day before the original date of the examination. And it said that I would suspend phone calls until the time that there will be a hearing. That's what my exact note is. There's no hearing, so I'm going to go ahead and reinstate your privileges.
Thank you, Your Honor.
I remind you that there is a no contact order that still exists, so you're not to have contact directly or indirectly with Shamala Bradley. So for those crafty individuals in the Ingham County Jail that think that they can use someone else's number, they can have the person get another number. It never works in your favor. I'm sure you did not enjoy having your privileges revoked. Calling the alleged victim is not worth it, okay? If you get the urge, you know what you should do instead? Call your attorney and talk about your urge, okay? And he'll remind you it's a bad idea, okay? Otherwise, your bond will continue as set. Any additional matters for the record?
No, Your Honor.
Nothing further. Thank you very much, Your Honor.
You're all set.
Thank you, Your Honor.
You're welcome.
We don't know now who the circuit court judge is. No.
Okay, all right.
So I'll email just the circuit court clerks and CCU, so that way, whoever it does get assigned to, they can just put it in there as quick as possible.
Very good. Thank you very much, Mr. Pfeiffer.
Of course.
Okay, on the record, in the matter of the people of the city of Lansing versus Willie James Jr., file number 23-02458. Are you Willie James
Yes,
Jr.?
ma'am. Yes, I am.
You can come to the table. Okay, Mr. Willie James, today is the date we're addressing a warrant. You were supposed to be before the court just 3 days ago.
Yes, ma'am.
And you were not here. What happened?
First, I have to apologize to the court for that because you did make a arrangement with me, and I just finished that arrangement and paid that debt off. But I came in, I think it was yesterday, do that, and the clerk informed me that I had missed the court date. Well, I've been going through quite a bit of medical problems. I got a sciatic nerve that fronted up on me here in the last several weeks, and it's a deteriorating disc in my back, and the doctor put me on some heavy medication. And I didn't realize until I came over to make the payment that he said I missed its court date. So he said, well, you can either talk to your attorney. So I tried to talk to Mr. Lee about it. He told me just to come on in and try to talk to somebody to represent me on it. But I think he's in another court hearing. So I do want to let the court know it wasn't intentional. It was due to the medication that I was on. It's some heavy medication. I slipped and missed my days.
Oh.
But that's the reason I'm here today, to honor the court's respect.
So you paid the suspension that you had, is what you're
Yes,
saying?
yes, yes. As you ordered in the initial agreement, I paid that off. And I will continue to honor the court's. I just didn't expect this nerve to flare from my back. And I'm pain right now.
Sorry that you're in some pain. Hopefully you'll get some relief or
Sure
some
need
other
it.
course of treatment to address that. I will quash the bench warrant and we'll reset this.
I don't know. I've got to see a physician, a specialist. I'm hoping they don't have to do any surgery, but where it may, and happen to me, I'll know that next Monday when I talk to this back specialist. But if I am in a position where I can't come in, I would definitely let the court know if I'm in surgery or anything like that. I would definitely inform the court.
Yeah, but you just need to make sure your attorney is aware or you call the court either way.
Okay,
If you have a conflict due to a medical appointment, okay?
I just,
Let's see. Sorry? Oh, yeah, right now the due date is scheduled for February 5th at 11 a.m., okay?
all right, Your Honor.
Okay, don't forget your date, stay in contact with your attorney.
That's the date here, isn't it? Yep. Okay.
Yep, and you do have the option of appearing via Zoom if you have a smartphone with video.
All right.
Okay.
I think I talked with Mr. Lee and I'm gonna work with him on top of some.
Yep, as you should. And then we'll see you on February 5th, sir.
All right, thank you very much, Your Honor.
You're
Sure.
welcome. Go to-
Did we do anything different with his mom or is he?
I washed it.
Oh, okay. All right. That just needs to go.
All right, thank you.
All right, you have a good day. Bro. You too, sir. All right.
Do we have, your client here?
Yes, Your Honor. I apologize for returning this.
Okay, no worries. Were we having an exam?
We are, yes, Your Honor.
Okay, let's get started.
So that just goes under the ROA.
Okay, on the record in the matter, the people of the state of Michigan versus Kenyon Marcel Lanier, file number 23-03389, counsel appearance.
Mr. Prosecutor Craig Petrowski on behalf of the people.
Joseph Yang on behalf of Mr. Lanier, who is present and to my right.
Okay, Mr. Lanier, today was the date and the time that was set for preliminary examination on a carrying concealed weapon and any preliminary matters before we call witnesses.
Nothing from the people.
Ron, just sequestration order. I'm not sure if anybody's watching that's live, but just a general
Sequestration doesn't include on live stream, that's for sure. It's sequestration for the purposes of your arraignment, of your preliminary examination. How many witnesses do you have?
I have 2 officers.
Okay, the sequestration is granted for the 2 officers. You can proceed.
Thank you, Your Honor. I'll go get, which one is first?
You gonna be hot, you probably gonna take that off. Oh, you good? Okay, appreciate it. So, I'm not asking if they won't grab you. She don't. I mean, but no, I've seen you. Yeah.
You're gonna go.
Oh. Yeah.
Over here. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do, Your Honor.
You can have a seat. Can you state your first and last name and spell both?
First name is Craig, Craig. Last name Fleeser, Fleser.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Officer Fleeser. Where do you work?
I work for the Lansing Police Department as a peace officer.
Okay, what are your duties in that role?
I'm assigned to the 3rd Platoon Road Patrol, which is take calls for service, conduct traffic enforcement, and other law enforcement duties.
Did you receive a call from dispatch on November 11th, 2023?
I did.
And what were you dispatched for?
One of my calls on that night was responding to 914 North Penn to respond for a hospital fight.
Objection, Your Honor. Hearsay as to the reason for the dispatch of what the 911 dispatch was.
You asked him, did he receive a dispatch?
I had asked him what he was dispatched out for.
Okay, is this being offered for the truth of the matter asserted?
No, it's just to establish why he was going to the location.
Objections overruled.
Thank you, Your Honor.
So you said you were just, what were you dispatched for?
I was dispatched for a possible fight, and then while en route, I was advised that a individual was heard over the phone saying, "Please put down the gun."
Your Honor, just to continue the objection about what dispatch, I believe this line of question is gonna go into kind of effect on listener. I do believe this is hearsay within hearsay. That's my objection, Your Honor.
Is it being offered for the truth of the matter asserted?
It's not, and I would also say that the statement made to the dispatcher would be an excited utterance.
Thank you. It's overruled. And this is not an issue with, there's a jury. I know when something's not being used for a certain purpose, I can categorize it for that, this section. At this point, that's not evidence to support probable cause. It's for the effect on the listener and to show us why he did what he did. Okay, you can proceed.
Thank you. So you had received a call and while en route, you became aware that one of the individuals may have had a gun.
Correct.
And I'm so sorry. Where were you dispatched to?
914 North Pine.
North Pine. Is that in the city of Lansing?
It is.
County of Bingham?
Yes.
State of Michigan?
Yes.
Did you go to that location?
I parked my vehicle just south of that location to allow myself to walk up and get some more situational awareness.
Okay. And what did you observe when you arrived?
When I arrived, I observed 2 individuals standing outside just west of 914 South North Pine, and they were standing next to an older style automobile, which I forgot to mention. While en route, we were also advised that the individuals were standing next to a older style vehicle. So while on approach, saw the two individuals standing next to that older style vehicle and tried to make contact with them.
And did you make contact with them?
I did make contact with the one of the individuals, yes.
Did he give you his name?
Yep, I identified him as Mr. Lanier.
Okay. And did you see his face?
I did.
Would you recognize him if you saw him today?
I do.
Is he present in the courtroom?
He is present in the courtroom today.
Could you describe where he's located in an article of his clothing?
He was located, well, when I first located him, he was.
I'm sorry, should be more clear. I'm sorry, not to interrupt, but where he's located in the courtroom?
Oh, in the courtroom. From my position, he is into the front and left of me. He's wearing a red hoodie and a black Nike coat on top.
Your Honor, please let the record reflect that the witness have identified the defendant.
Any objection to identification?
Not for purpose of agreement, Your Honor.
Identification is made.
So when you made contact with the defendant, what did you do?
I walked to the defendant, told him to walk toward me, keep his hands where I could see him. That was because I thought there might be a firearm present. And then as he is walking towards me, I informed him that I was going to conduct a Terry pat down because I believe reasonable suspicion that a crime was afoot, and I had reasonable suspicion that a dangerous weapon might be in play. And then I went to secure Mr. Lanier behind with hands behind his back.
Okay. Before you secured him or anything past that point, could you see any weapons on Mr. Lanier's person?
I could not.
You said that you went to secure him?
Yep, I had him face away from me and then informed him that I was going to conduct a pat down on him.
Okay, and did you do so?
I was about to, and then prior just to pouring my pat, Mr. Lanier informed me that he had a firearm on his body.
Okay. And at that point, could you see a weapon?
I still could not know.
What did you do once he informed you he had a weapon?
As soon as
Excuse me, I should be more specific. When he informed you he had a firearm on his person?
When he informed me he had a firearm, I did place him in the cuffs just for my protection to make sure that he was secured.
And then what did you do after he was placed into handcuffs?
When he was placed in handcuffs, I conducted my pat down. I identified the firearm being in his front right coat pocket, or excuse me, pants pocket, and I removed the firearm, cleared it, and then I temporarily handed it off to Officer Traverso so I could continue the rest of my search on Mr. Lanier.
And I forgot to ask earlier, did when Mr. Lanier said that he had a firearm on him, did he say where on his person it was?
He did, in his front right pants pocket.
And you had just stated that's where you found the firearm when you patted him down?
Yes.
Can you describe what the firearm looked like? Basically, just any details you can remember about what the firearm
It was a black Glock. It also had what we call an extended magazine, which was protruding farther than what we would consider a standard magazine. I didn't say it was black in color.
Did you speak with Mr. Lanier after? Well, actually, no. Sorry. So you said you handed the firearm off to Officer Traverso.
Correct.
What did you do after that?
After that, I put Mr. Lanier in the backseat of my vehicle. I read him his Miranda rights, and then we had a conversation about what was happening. I still had to get into why I was dispatched there. I didn't know if another crime had occurred. So we talked about what happened, which ended up being nothing that we could, a criminal case for that sake. And then we had an additional conversation about the firearm, where it had come from, and why he had it on him.
So what did he state about the firearm? What did he inform you about?
So he advised me that the firearm belonged to his brother. He also advised me that the paperwork for the firearm was in his wallet, which is in the center console of the vehicle that I located him by. He also informed me that he had an additional magazine and a holster for the firearm in the vehicle.
Was Mr. Lanier in possession of keys to the vehicle?
He was in possession to the keys. He gave me the keys to the vehicle. He gave me consent to search the vehicle to go find that wallet and the paperwork, which I went and retrieved.
So you did, and he gave you consent to search, and you did do a search.
I did.
Was the paperwork the only thing that you found in the vehicle?
No, located in the front driver's side door was the additional magazine and holster for the firearm.
And that was consistent with what he had told you?
Yes.
Further questions?
Cross-examination.
Thank you, Your Honor. Officer Fletcher, my name is Joseph. If I need to rephrase or speak up, please let me know, okay? How did you prepare for today's hearing?
Prior to, I reread my narrative from that night of the incident.
You reread your report, is that
Yes.
correct? All right. Earlier you stated that Mr. Lanier was standing west of 914 North Pine, correct?
Correct.
Okay, and he was in the front yard, is that correct?
Not when I first located him. When I first located him, he was between the sidewalk and the actual road.
He was between the sidewalk and the actual road?
Yes.
So on the front grass patch?
Yes.
Okay.
Walking to the east back towards 914.
Okay, so when, let me back up a little bit then. So when you first observed him, was your body cam on already, or did you observe him before your body cam was on?
I would have still been in my vehicle at the time, so it was prior to me activating my body cam.
Okay, and so he was in the front yard patch when you first observed him, is that correct?
Correct.
And then at that time, he goes back into the front yard, is that correct?
Yes, walking back towards front door of 914, which is an apartment complex.
Okay, and then you approach him, and then you ask him to come towards you, is that correct?
Correct.
Okay, and at that time, he was in the front yard of 914, correct?
Correct.
Okay. From your observation, when you first saw him before you turned on your body cam, did you observe any firearms on him at that time?
I did not, no.
Okay, go ahead. And during this interaction, was Mr. Lanier complying with you at all times?
He was.
Okay, and he actually was the one who said that he had a firearm on his person, is that correct?
That is correct.
Okay, and to your knowledge, do you know if he was legally there? Was he allowed to be there?
Unknown at that time.
Okay, did you find out afterwards if he had permission to be there, his family or friend's house at all? Did you learn any of that information at all?
I did later, yes. He was legally allowed to be where he was at.
So he's legally allowed to be where he was at that time, correct?
Correct.
Okay. And as far as you know, Mr. Lanier wasn't prohibited from carrying a firearm like a felon in possession or anything like that, as far as you know, correct?
At the time, I did not know.
Nothing further, Your Honor.
Redirect.
I just have one question. At any time when you spoke with Mr. Lanier, did he inform you if he, whether he had a CPL?
He did not inform me. We had that conversation when he was in the backseat of my vehicle after I placed him in the handcuffs.
Okay. And did he have a CPL?
He did not have CPL.
Further questions?
May this witness be excused?
Yes, he may.
Thank you, officer. You may be excused.
Thank you, Your Honor.
Okay. I know you wanted to have another witness, but I'm not sure why.
I was actually just gonna say that I'm not gonna call another witness. I just had him just.
Very good. The defense need to call witnesses today?
No push for the defense, Your Honor.
Argument? Thank you, Your Honor. I won't belabor the point here. This is fairly cut and dry. Officer Fleaser it was not able to see a pistol or a firearm on the defendant's person prior to patting him down. Once he did in fact pat him down, he found a firearm on defendant's person. Defendant told him the firearm was there, so he knowingly had the firearm on his person, and he also knew about and had all of the information related to the firearm stored in his vehicle. Thank you. Oh, sorry, wait, yeah, the people would ask that the court find this case over as charged in circuit court.
Mr. Yang.
Thank you, Your Honor. I would ask that this court dismiss the case. There's no probable cause to bind this case over. Mr. Lanier was observed in the front yard patch crossing the sidewalk over. And then when he had contact with the officer, he was actually in the front yard of the home. That is a curtilage of the home. If you read the statute 750-2272, a person shall not carry a pistol concealed on or about his or her person, or whether concealed or otherwise in a vehicle operated or occupied by the person, except in his or her dwelling, a place of business, or on other land possessed by the person without a license to carry. It is true he did not have a CPO. It is true that he had a firearm on his person, but it is also true that he was on the curtilage, which is a land that was possessed by him. He had the right to be there. The officer testified to that. So he was a guest at the home. Therefore, he had the right at that time to have a firearm on as a guest of that home in his possession.
Land that's possessed by the person. is
That
not-
extends, Your Honor, that extends to somebody who gets permission, Your Honor. If
That you can give, when I invite you to my house, I don't give you permission to possess my property or my land.
Your Honor, if I think possess is at that time, do you have the right to be there? Does he have the right to be there? And it was clear that he had the right to be there because it was a family member's home.
I recognize he had a lawful right to be at this house. My understanding from the officer's testimony is that when he approached, he saw two individuals sitting or standing next to an Oldsmobile.
Correct. And
Well,
so
the car would be parked on public property or private property?
Your Honor, that was not made clear. You said it was in the driveway. The driveway is private property, Your Honor.
I don't remember him saying driveway.
But that's, I guess, so
That's not evidence.
well, he said that they were standing next to a vehicle, older model vehicle is what he said.
Correct. So the argument that you're making that he was on curtilage was not brought into evidence.
Your Honor, I asked the officer if he was in the front yard when he first made contact with them before he asked him to come to him. And he said yes. Therefore, he was on curtilage, which is the front yard. So that is what
I recognize he was there when the officer first approached.
Correct.
But again, he was not, the officer responded to a call of an incident. He sees a vehicle that matches the description. He sees two individuals near an Oldsmobile, which also matches the description. And this is not, at least there's no evidence here to tell me that this is this defendant's property. I'm not going to take the opinion that someone invites you to their house and now you have possession of their property.
So
that's not lawful possession of property.
Your Honor, so I guess that'll be my argument. My first argument is that he had the right to be there. He had permission to be there. And he was on the curtilage. Therefore, the owner's rights extended to him because he was there lawfully. That is my argument. The second argument.
What legal basis are you standing on that when you are invited to someone's house, that the privileges or the rights that the owner has are now extended to you?
Your Honor, there's some additional case law. I don't have that with me, but there's case law on that. But that is what I stand on is that it does extend to.
Well, but without that case law, I don't want to hear it because when I invite someone to my house, they don't have the right to invite other people to my house. They don't have the right to stay at my house. They don't have the right to sell my house. The rights that I have as an owner does not extend to someone just because I invited them to be on my property. And so unless you provide me with some legal basis, that sounds like an argument for a motion that you're going to file at the circuit court.
Thank you, Your Honor. My second argument is that there was no probable cause to do a Terry pat. I objected earlier as to what the 911 dispatcher said to the officer. The officer did not hear this directly from the caller. It was a caller who told the 911 dispatcher who then told the officer. Yes, the officer went there, but for the officer to do a Terry pat, there must be some reasonable suspicion, some probable cause that a crime has occurred. Therefore, if the truth of the matter asserted was not allowed, therefore there's no probable cause. He's literally just walking down the street. He can't just do a Terry pat because he wants to do a Terry pat. If the court says that truth of the matter asserted was not allowed and purely just to set the basis of why the officer was
Why
there.
the officer reported there.
Correct.
He was reported there for a dispatch for a fight, which is not truth of the matter asserted. This is why he was reported there. Because there was a dispatch of a situation going on there. He's there to investigate. He arrives to the property. He sees individuals that meet the description of why he went to go investigate. He calls one of those individuals down and he has a conversation with them, to which the person admits, volunteers information that they have a firearm on them. Then the officer testified that he patted him down, that he secured him in weapons due to that admission and then patted him down.
Your Honor, he based on what I remember, he patted him down. He did a Terry pat first, and then during that Terry pat, that's when Mr. Lanier admitted that there was a firearm there. So
that's not what he said in his testimony. His testimony said that he patted him down, and he said he secured his arms in cuffs due to the admission of him saying that he had a firearm, and then he patted it down and located that he told him where to find it. That was what he said.
Thank you, Your Honor. So therefore, those are two bases that I asked that this case not be found over. Thank you.
Thank you. Today was the date set for a preliminary examination. Burden is on the prosecutor to meet a very low burden. It's that of probable cause. That's more than mere suspicion that a crime was committed, and not as much evidence that they would need to prove beyond a reasonable doubt at trial. Beyond a reasonable doubt is extremely high burden. That's not what we're dealing with today. It's more than mere suspicion again. And so we had one officer testify that and this is Officer Craig Fleeser from Lansing Police Department. He testified that he reported to the area of 914 North Pine Street, City of Lansing, Ingham County, State of Michigan, due to a dispatch call for an altercation, that when he approached, he saw two individuals that they were next to an old style Oldsmobile. Officer made contact with one individual that he identified in the courtroom as the defendant, Mr. Lanier. The officer indicated that he asked the defendant if he had any weapons on him. The defendant indicated that he did have a weapon on him. He told the officer that the weapon was in his front right pocket. Officer testified that he secured the defendant's arms based on the indication that there was a weapon, and that he did performed a pat down, that he located a firearm in the right front pocket, which is where the defendant told him it was, secured the firearm, he said, and he described that firearm to be a black Glock with an extended magazine, that the defendant provided information to the officer advising that the firearm in fact belonged to the defendant's brother, and that the paperwork was located in the vehicle. He provided the officer with the keys to the vehicle and gave consent for the officer to search the vehicle. Officer also testified that the defendant did not have a valid CPL. Defense counsel did question the officer about where the defendant was when the officer first approached. And the argument is made again that the defendant was on the curtilage of the property or on private property, and that the privileges or rights extended to the owner should extend to the owner's guest. The court disagrees with that argument. The privileges or the rights that owners have do not extend to your guests just because you were allowed to be or visit at my property. That would also render the idea that if I allow the workers from Amazon Prime to be on my property to deliver products, that doesn't give them the right while they're in my driveway to violate concealed weapons laws because I gave them the right to be on my property for the purposes that they're there. So I completely disagree with that line of analysis and that questioning. I believe there's overwhelming evidence to support probable cause because we had a valid reason why the officer was there. We had the officer approaching and seeing individuals that meet the description of what he's reporting there for. And then we have a defendant who volunteers the information that he has a firearm and where the firearm is and who the firearm belongs to and keys to the car and a search of the vehicle. With that being said, the court is satisfied that this matter has sufficient probable cause. Case will be bound over to the circuit court. Bind over date is going to be January 24th. That's the date the circuit court gets the file from the district court. Mr. Lanier, you do not need to meet or to report to the circuit court on that date, okay? Your next court date will be a pre-trial in circuit court unless your attorney makes a motion for a new arraignment date. I'm not sure if he would, but he sounds like he's going to file a motion of some sort over there. You'll be notified of your next court date, okay? On this matter was set at 2,010%. That will continue. I'm really confused about no contact with it. Was there a co-defendant?
Your Honor, there's no, I guess, alleged victim or co-defendant as far as I know. So if there's any no contact order, if it does exist, if you let us know so I can explain to
Yeah,
Mr.
there's
Lanier
a
what
no
that means.
contact order. It says no contact and no association with Wyvon Versa.
Oh, the guy that got arrested?
I'm not sure why that would be a no contact order.
Your Honor, Yvonne Verser is in fact a co-defendant in this case. Or at least he's listed as such on the complaint.
Okay. Why would we have a no contact order for a co-defendant? I have no idea what's going on here.
That I'm not sure of, but that is his relationship to this.
That's what I thought that there was a co-defendant. Did Mr. Versa wait last week? I thought I just saw Mr. Versa.
Yeah, he was here recently. If I could take my best stab at the no contact order, my guess would be because there was the dispatch was for an alleged assault or fight with the weapon between the two.
Oh,
maybe that's the reasoning there. But
I don't know. They weren't obviously. They were Mr. Versa. I'm sorry, Mr. Lanier is not being charged with any allegations of assaultive actions against this individual. So I don't think that a no contact order would be appropriate. It didn't even sound like he was aware there was no contact order.
That's correct, Your Honor. He has no reason to have contact with that gentleman anyway, so.
Yeah,
that
but
was struck.
yeah, I mean, that means with the no contact order, probably has how many feet you could be within this person's, and probably need to know that.
Yeah.
It just says do not associate with Mr. Versa.
I didn't even know his name.
But to the extent that Mr. Versa wants to associate with you, that's your business at this point. I don't see where you've been accused or charged with any assaultive or threatening actions during him. But you do have a bond condition that you're not to engage in any assaultive or threatening behavior. So that will continue anyways. I'll remove the no contact order for the purposes of, I don't believe they're appropriate under the circumstances. A bond otherwise will continue. Any additional matters for the record?
Nothing from the people.
Nothing for the defense, Your Honor. Thank you.
Thank you. You're all set. And is that all we have for the morning?
That's all for the morning. Then there's 2 this afternoon.
The conjuring and
Both
Jones.
Yeah.
Are they related?